Everything that is explained in this video is summarized from CoinMarketCap. And also, please don't forget to support my channel for more XRP updates and some other cryptocurrencies as a whole. Now take a look at this. SEC lawsuit. Ripple's Elon Motion faces SEC opposition, potential delays in final judgment. A new development has occurred in the continuing legal dispute between Ripple and the United States Securities and Exchange Commission. The SEC has expressed opposition to Ripple's desire to conceal specific information concerning its business activities. An opposition has been submitted by the Securities and Exchange Commission in response to Ripple's request to conceal private business information, which includes discounts that are granted to institutional buyers of XRP. James K. Furlan, an experienced defense attorney, offered some insights into the resistance of the Securities and Exchange Commissions, disclosing the regulatory agency's position on Ripple's omnibus sealing request. Ripple's seal motion was met by a response from the SEC. In the past, Ripple attempted to conceal exhibits that were associated with its confidential business activities. These exhibits included information about discounts that were made available to institutional purchasers of XRP. However, the Securities and Exchange Commission contends that making this information public is necessary for achieving openness and comprehending the merits of the case. As part of its argument, the Securities and Exchange Commission asserts that Ripple's motions to seal would prevent the public from seeing key evidence that is pertinent to the court's evaluation of the remedies case. It is interesting to note that the Securities and Exchange Commission primarily disputes Ripple's attempt to conceal financial information about discounts granted to institutional buyers of XRP. This suggests that openness is critically important for appropriately calculating penalties. In addition, they are opposed to the suppression of particular financial documents, stating that the information contained in these statements is essential to the process by which the court makes decisions. According to the authority, Ripple has not demonstrated how the dissemination of public information could result in serious harm. Some of the material is already available to the public, and it deems Ripple's financial disclosures to be out of date. It is important to note that although the court will finally decide which evidence and documents need to be sealed, there is discussion within the XR community regarding the possibility of delays in the issuance of the final verdict. In particular, there are talks taking place around Andre Fox, a well-known accountant for the Securities and Exchange Commission, and whether or not she ought to be deemed an expert witness or a summary witness in the case. Because the situation has not been settled, the legal processes between Ripple and the SEC could be further prolonged, which would add another layer of complication to the already complicated dispute. Despite this increase, experts are warning that the lack of clarity around regulatory affairs may keep prices low. In response to the Securities and Exchange Commission's objection to Ripple's request to conceal financial and institutional sales data, whales are reportedly beginning to dump their holdings in XRP. The SEC opposition to Ripple's request for financial details is fortunately the only thing that can be said. It would appear that they are more concerned with the punishment than with the position of XRP. Even though there has been no discernible advancement toward conclusive resolution, the protracted conflict between Ripple and the United States Securities and Exchange Commission continues to increase in intensity. The most recent regulatory action consisted of the submission of the regulator's response to the company's petition to redact and seal particular evidence concerning the parties' briefing on remedies. Opposition to the sealing of XRP details is filed by the SEC due to the significant risks that Ripple Labs was exposed to. Ripple has previously requested that the court redact and seal the financial reports, as well as the specifics on post-complaint XRP, institutional sales, and other confidential information. The most recent court filing indicates that the United States Securities and Exchange Commission has submitted a response to Ripple's application to redact and seal information, expressing opposition to the proposal in part. The Regulatory Commission asserts that Ripple's request to conceal financial and security sales information from the general public is impermissible, and that the material at issue, which includes financial numbers and other details, is essential to the intended remedies. It should be brought to your attention that the Commission does not have any concerns with the act of sealing Ripple's most recent financial statements as a whole. Although the company has requested that the 5 exhibits in question be sealed in their entirety, as well as several of the redactions that it has suggested for the remedial briefings, this request is not forbidden. On the other hand, it is vehemently opposed to the proposal made by the corporation to redact information about its revenues and expenses dating back to 2014. The Securities and Exchange Commission believes that this data has the potential to shed further light on Ripple's XRP sales and to play an essential role in the legal process, and other confidential details are sealed and redacted. This motion was made in light of the severe dangers that Ripple Labs was exposed to. On the other hand, a lawyer who supports XRP named Bill Morgan thinks that Ripple will lose the move to seal. The SEC asserts that it will make Ripple's record public. According to the most recent court filing that was made public on May 21, the United States Securities and Exchange Commission has submitted its response to Ripple's move to redact and seal documents, and it opposes the motion in part. According to the Securities and Exchange Commission, Ripple's request to conceal financial and securities sales information from the general public is illegal. The SEC asserts that the material at issue, which includes financial numbers and other details, is essential to the remedies that are being asked. Ripple's redaction request, according to the Securities and Exchange Commission would conceal public information that is essential to the court's findings during the remedies phase and to the public's comprehension of the penalty amount. Ripple's current assets, which are relevant to the penalty amount, the number of recent sales, which are relevant to injunctive relief and fines, revenues and expenses, which are relevant to disgorgement, and the size of discounts offered to certain institutional investors, which are relevant to investor injury, are all included in the details. In addition, the regulator contends that Ripple did not provide sufficient evidence to demonstrate that the information that is readily available to the public would result in a significant injury that would require protection. Additionally, it was stated that the financial particulars and other material are outdated and out of date, and that some evidence is already accessible to the general public. Furthermore, it was stated that Ripple's reliance on previous sealing approvals granted by the court in the current issues is not valid. A lawyer who supports XRP named Bill Morgan made the following statement in response to the conclusion of the moan. Ripple will largely lose the motion to seal. In addition, he stated that the Securities and Exchange Commission has clarified that none of the sales to institutions that offered discounts were ODL contracts. However, they are still seeking a permanent injunction to halt ODL sales. As far as he's concerned, SEC is aware that the ODL contracts are not investment contracts. The most recent gain occurred after the SEC requested that exchanges update their 19b4 reports, which resulted in an increase in the likelihood of the approval of a spot Ethereum ETF to 75. On the other hand, analysts think that the price will continue to trade at lower levels throughout. The Securities and Exchange Commission seeks the court to grant an order to make public the specifics of Ripple's business. Ripple had previously requested that the court retain the financial reports, details on post-complaint XRP institutional sales. The information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page. Before making any decision about investments, we strongly advise conducting independent research and have consulting with a knowledgeable professional.